Remedies in tort law. Let's make sense of it. So why do we even have remedies? So picture this. Someone's actions have landed you in a mess. Maybe you've been hurt or your favourite things have been damaged. Should they just shrug and carry on as if nothing happened? Of course not. So remedies in tort law, it's all about being there to put things right. The whole idea is to get you, the person who's been wronged, back to where you'd be if none of this ever happened. It's about fairness, about keeping everyone in check and making sure people's rights aren't just empty words. So in tort law, there are two main types of remedy that you'll hear about. We've got damages, which is money to make up for your loss, and we've got injunctions, where the court tells someone to do, or actually to stop sometimes, doing something. Let's take a closer look. We'll start with damages. So damages mean money paid to the person who suffered harm. And the point isn't to punish the wrongdoer, well, except occasionally in a few rare cases. In fact, the focus is on making things right for the injured person. The classic phrase here is restitutio in integrum. And that's basically the law's way of saying, let's get back to how things were. Now, there are different types of damages. It's not just one size fits all. Let's take a closer look. We've got special damages. So these are for things you can put a number on, like medical bills or lost wages. If you missed a shift because of your injury, well, special damages cover that lost pay. General damages, these are a bit trickier because it's hard to put a price on everything. Pain and suffering and missing out on fun, these all fit in here. Pecuniary damages is just a fancy way of saying damages for money you've lost or had to spend, and non-pecuniary damages, and that's the opposite. This is about stuff you can't put a price tag on, like emotional distress. We've got nominal damages, so sometimes the court says, you're right, the other side broke the rules, even if it didn't actually cost you anything, so you'll get a tiny amount, a nominal amount, just to make the point. Then we have aggravated damages. If the person who wronged you made things worse, maybe by being disrespectful or especially unkind, well, these damages are like extras. You get a bit more for the extra hassle. And finally, we have exemplary, also known as punitive damages, and these are really rare. You can think of them as the court's way of making an example out of someone who's behaved shockingly badly to warn everyone else. So mitigation of loss. Frankly, you can't just sit back. If you're hurt, it's not enough to just wait around for compensation. You're expected to help yourself as much as you reasonably can. Go and see a doctor, look for another job if you're able, that sort of thing. And the court will only pay up for losses you really couldn't avoid. So if we take the British Westinghouse Electric Company versus Underground Electric Railways Company, as an example, the party that suffered the loss actually saved money by upgrading their equipment. So the court said, we're counting that saving. Ways to get paid. So you can get your damages in a lump sum, all the compensation in one go, or a structured settlement. And this is a smaller, regular payment over time. And the law encourages this, but it's still not that common. Few cases here for you to have in your back pocket. You've got Thompson versus Metropolitan Police Commissioner, aggravated and exemplary damages for oppressive police behaviour. You've got Rooks versus Barnard from 1964, and this is the one that decided when exemplary damages are allowed. And you've got Heel versus Rankin from 2000, which tweaked how courts work out pain and suffering damages. So injunctions. Money isn't always enough, is it? Sometimes you just want the neighbour to stop doing whatever's causing the grief, and that's where injunctions come in. So these are court orders to either stop someone from doing something or to make them take action. So instead of compensation, it's about preventing more harm or getting things sorted properly. There are different types. You've got prohibitory injunction, which is the stop doing that injunction. Mandatory injunction, the start fixing that problem, like removing a nuisance from your property. Interim or interlocutory injunction, which is a temporary measure until the final court decision. And finally, you've got the final or permanent injunction, and this is a lasting order, and it's usually made at the end of a case. So when will the court actually grant an injunction? I mean, would just giving money solve the problem, they ask, or is an injunction really needed? They consider the balance of convenience. Does the remedy help you more than it harms the other person? Also, public interest comes into play. So does the whole community care about the outcome? And then it considers how both sides behaved. So did you act quickly? Did you wait until it was too late? So one example there in the middle, that's Miller versus Jackson. That's the 1977 case. And cricket balls kept landing in someone's garden, but the court said no to an injunction because stopping the cricket matches would ruin things for everyone else in the community. So that's a good example of a public interest consideration. You've also got the American Cyanamide Company versus Ethicon Limited, and this set the standard for when to grant interim injunctions, and the Minerva Compania versus International Bulk Carriers, and this brought in something called a freezing injunction, and the idea is to stop people moving assets out of reach before a decision is made. That's naughty. Okay, moving on. Let's take a look at some strengths and weaknesses now. So, strengths. Well, compensatory damages help people bounce back from loss or injury. They cover things like medical bills, lost wages to make things right. There are lots of types of damages, so most situations have a remedy, whether it's money for your losses or just recognition that you were wronged. That's a good thing. Injunctions are handy for stopping harmful actions before they get out of hand, like stopping someone from building on your land, for example. And finally, claimants are expected to act reasonably and not let their own losses pile up when they could have taken steps to prevent them. There are some weaknesses too, though. Well, after all, money can't fix everything. It can't fix things like emotional pain or broken relationships. Most of the time, cash helps with the bills, but it doesn't cover all the hurt. Getting paid in smaller amounts over time, the structured settlements we talked about, it's helpful for long-term injuries, but sadly it's not common. Most people just get a lump sum and that can run out too fast. Punishing damages, punitive damages we looked at, those exemplary ones, are hard to get. So bad behaviour sometimes goes without, much in the way of consequence. And finally, injunctions, which we know are court orders to stop something, these are tricky to enforce, and judges have to think about what's best for everyone and not just the person asking for help. Theories to remember behind all these remedies are corrective justice. Now, this theory is all about making things right when someone has been wronged. The idea is that if someone causes harm to another person, well, the law should do its best to restore the balance. For example, if you accidentally damage someone's property, well, corrective justice means you should compensate them, so they're in the same position as before the harm happened. So it's less about punishment and more about fairness and putting things back the way they were. Another theory is economic efficiency, and this is really an approach that looks at how the threat of having to pay damages can actually encourage people and businesses to act more carefully. I mean, if you know you might be held financially responsible for being careless, well, you're more likely to take steps to avoid causing harm in the first place. So in other words, the law uses the possibility of having to pay up as a real incentive for everyone to behave sensibly and avoid unnecessary risks. And that's good, isn't it? Because it benefits society as a whole. And then we've got retributive and distributive justice. Well, sometimes damages aren't just about fixing what went wrong. They're also about sending a message or making sure things are fair across the board. Retributive justice is about punishment. So if someone's actions were particularly bad, the law may award exemplary damages to show that behaviour won't be tolerated. Distributive justice, on the other hand, is about spreading fairness, like making sure compensation is handed out so that everyone is treated justly, especially when harm affects a wider group of people. do have some ideas for reform as well here. So using structured settlements for more long-term injuries. So paying out money over time instead of big lump sums. I mean, that can make sure people with ongoing needs, like medical bills, for example, that they don't run out of their funds too quickly. So it might be especially helpful if people have got very long-term lasting health issues. Another idea for reform is to allow exemplary punitive damages in more cases. We know that they're only used for the really bad behaviour. Perhaps using them more, maybe that would help stop companies or people from acting recklessly. Hits them where it hurts after all, in their wallets. Another idea for reform is to make non-financial damage awards a bit clearer and fairer. So right now, money for things like pain and suffering is given out pretty randomly, to be honest. If the rules were clearer, people would know what to expect and they'd get treated more equally. And another reform idea is to speed up the process for injunctions. It can take a long time to get to court and to get a court order to stop harm. So making this process faster while still being fair to everyone, well, that would really help people get the protection when they really need it. So let's break down how different torts are matched with their remedies using this table as our guide. And I'll just walk you through each row so you can see what kind of harm each tort covers and what kind of remedies are typical. And I've also included their key case for each. So first up is negligence. So here the main types of harm are physical or mental injuries and property damage. The typical remedy is compensatory damages, and we know that that means money awarded to help the claimant recover what they've lost. This could be special damages for things like medical bills and general damages for pain and suffering. The classic case there, West versus Shepherd. For exams, remember that the focus is on helping the claimant get back to normal, and injunctions, meaning court orders to stop someone doing something, are going to be pretty rare in negligence cases. Next, we have occupiers' liability under the 1957 Act. So this is the one about the injuries or property damage to lawful visitors, so people who are actually allowed to be on the property. So again, remedies would be damages, general and special. And the case to know is Wheat versus Laken from 66. So a little tip here, it's a lot like negligence, and you can recover damages for property loss as well as injuries. Let's look now at the other Occupiers' Liability Act. This is the 1984 Act, and things shift a bit here because, of course, this covers injuries to trespassers. But damages are actually still available, but not for property, just for injury. So Tomlinson versus Congleton, that's your key case. Now, duty of care, remember, is going to be lower here. I mean, you were a trespasser after all. And if the claimant was taking a clear risk, well, their damages might be reduced. We've got private nuisance now. That deals with issues about the use of enjoyment of land. Think about, noisy neighbours or unpleasant smells interfering with your home life. The usual remedies are injunctions to stop the nuisance or damages, maybe if that's not appropriate. You've got Kennaway versus Thompson from 81 as a leading case. And injunctions are common here unless stopping the nuisance would go against the public interest. We have Rylands versus Fletcher, and that's about the escape of dangerous things. This was the burst reservoir flooding a neighbour's land. So the remedy is damages, but only if the type of harm was foreseeable. So Cambridge Water Company versus Eastern Counties Leather from 1994 is the case to remember. The liability is strict, but there's still that foreseeability requirement. And finally, we're going to look at defamation or trespass to the person. And this covers harm to reputation or direct interference with someone personally. And the main remedy is going to be damages here. So these can be aggravated, they can be exemplary, especially if the conduct was particularly bad. So Thompson versus MPC, 898, that's a good case here. And the goal is usually to protect reputation, but sometimes it's also about punishing the wrongdoer. So in short, Each tort tends to have a go-to remedy that fits the kind of harm it causes, but there are exceptions and important details. Knowing your key cases and what the courts are aiming to do, whether it's compensating, deterring, stopping harm, hopefully that will help you make some sense of the remedies across the torts. So let's just finish with exam tips, what to watch for. So negligence and occupier's liability, first of all, it's mainly about damages, covering money and personal losses, remember. Nuisance, injunctions are important unless the public interest comes first. Strict liability, like Ryland's, damages only if the harm could be foreseen. And intentional torts. So these are higher damages, aggravated or exemplary, and they can be awarded to discourage bad behaviour. You've also got a few key tips there just to look out for. And let's finish with a key takeaway, some final thoughts. So that's remedies in tort law, designed to put things right, whether that's through compensation or making sure problems stop. So if you can get your head around the types, the cases, the exam tips, hopefully you should be ready for anything that your exam paper throws at you.